ERISAfire is the special ops of health and welfare employee benefits compliance, serving employee benefits brokers and their employer clients. We offer you peace of mind that your compliance risk is managed holistically, even when the benefits environment is ever changing. We back our work with a quality guarantee and the assurance that our attorneys and paralegals will catch what others miss. We walk alongside you with continued compliance support to protect your business and help you succeed. Here's some of our practical, actionable guidance. Please enjoy this video from the ERISAfire archives.
All right, everyone, welcome to ERISAfire's COVID-19 Town Hall. We thank you for joining us each week, and today we have a special guest on that we'll tell you a little bit about here in a moment. But first, we'll do a couple housekeeping items. So if you have any audio issues, we found it helpful to dial in by phone. Sometimes that may help you. So I have this information available for you here on the screen. I'll also share it by chat to everyone here momentarily. If you have your video on, if you don't mind turning it off unless you're talking, that would be helpful just because we have a lot of people on the line that'll help it make a little more clear audio and video for everybody. So we're going to have an opportunity to ask questions, and I'd like to be able to call on you by name. So if you don't mind, you can click on Manage Participants, and then you'll see by your name that there's an option to rename, and that if you could put your first and last name in there, so I can call you by your name rather than iPad number 3. You'll also see down on the bottom menu chat, and it'll default to everyone, and feel free to go ahead and chat your questions in there, and we will get to everyone throughout the time period. If we don't get to your question, we will address that at the end. So we have a little giveaway for you all. We had mentioned that David has been working on a piece for Bloomberg Law that's now out about furlough as an employer response to pandemics and economic crises. If you'd like a copy of that, please go to the chat and privately send me your email address, and I'll get that over to you. So feel free to do that anytime throughout the presentation today. So for those of you who don't already know David Lefevre, he's our host. He's the founder of ERISAfire Benefits Compliance Solutions and managing attorney of Lefevre Law PC. He's been employee benefits attorney for 13 years. His practice focuses on assisting clients in complying with ERISA and other employee benefits laws pertaining to health, welfare, and retirement. He's a contributing author to Bloomberg Law, featured on Benefits Link, and he'll be leading us today. Over to you.
All right, thank you, Kendra. So, wow, a lot of things keep happening and keep changing. And as time goes on and the DOL gets more opportunity to write things down, it publishes more guidance and issues new FAQs that undo or clarify some of the things they said in prior guidance. And it seems like things are changing all the time. So a few kind of modifications in how it is that we are running this presentation. Here at the beginning of the hour, we're going to cover kind of a lot of things, but not very deep. And this is in an effort to kind of spur some questions from folks. Then we're going to bring on Mr. Eric Buchanan as a guest speaker today. I'll introduce him in just a few minutes. And we'll have a conversation about the plaintiff bar's perspective on kind of what's going on. And this is a fantastic opportunity, by the way, for folks to get the perspective of perhaps the other side and hopefully manage things on the front end before they become issues on the back end. But just here, to kind of cover broadly some of the developments in the last week or so, there have been, particularly on the coasts, the developments as far as paid leave ordinances and state laws in particular in Washington State and in New York State, that in some ways conflict with the federal requirements, but in other ways expand upon it. For instance, New York's, I believe, is for employers above and below 500. But what's interesting about that is that it expands the federal one, which only applies to employers with fewer than 500 employees. Seattle has an interesting development there in that, if you recall, under the FFCRA and the tax credits that were created by that, IRS issued some FAQ guidance that says you need to have, if you're claiming a tax credit, you're getting free money from the government, you probably ought to document that and have it on file. And one of the things that it says you should be asking for is evidence that somebody is going on paid leave for one of the qualifying reasons. Well, one of the reasons is that a doctor has told you to go to self-quarantine. Seattle, interestingly enough, has banned the ability of employers to ask for doctor's notes when asking for paid leave, which potentially puts an employer in the Seattle region at a really tough spot because it is prohibited from asking for the documentation that IRS requires in order to claim the tax credit. I have confidence that this will get worked out, but it does illustrate some of the difficulties of doing the right thing. And at the end of the day, so what is an employer to do if it's told by one regulatory body that you have to do something and another regulatory body that you are prohibited from doing something, the very same thing? What do? I think at the end of the day, you're just going to have to do the right thing and it will all sort itself out in the end. With respect to that one in particular, just kind of off the cuff a little bit, there are very stiff penalties, and what I'm doing here is I'm going to try to give you a framework for how to approach some of these conflicting burdens, and that's the objective here, because one of the things that we're going to cover today is sometimes conflicting obligations or conflicting mandates, and how do you resolve that? And so the framework that I would suggest is looking at both probability and magnitude. So if you go back to high school statistics class and assessing kind of the probability of enforcement and the magnitude of the penalty, in this case, the Seattle local ordinance that prohibits you from asking for doctor's notes, it comes with a stiff fine, per employee, per instance kind of fine of upwards of a couple $1,000. And I've read that Seattle is actively enforcing its paid leave mandate requirements. So you've got a very high probability on that one, and the magnitude is very real. You got real dollar amounts. But on the other hand, you've got an IRS mandate that says you should be documenting it, but you don't have to turn that documentation into IRS. You should just have it on file. So if I'm an employer, so I'm gonna take my lawyer hat off for a minute here, put my businessman's hat on. And so I'm weighing these two things. And again, I'm providing you a framework for how to approach these things. I got my businessman's hat on. I've got, a high probability, very certain magnitude of a problem here with fines from the city of Seattle versus a requirement by IRS, generally speaking. And if I'm going to claim a tax credit, I probably ought to have the documentation on file, but I don't have to actually give it to IRS. I'm probably going to I'm going to comply with the Seattle mandate because there's real enforcement there. And I'm going to try to maybe clean things up after the fact with IRS. Again, lawyer hat off, businessman's hat on, because I can probably get a documentation from the employee maybe after things have settled down from the city of Seattle. I have some confidence that people are going to generally do the right thing, including bureaucrats and city council members and the IRS. And we've seen evidence of that. So one other development, let's see, where is it in our list here? It might not be under. One other development I think was kind of interesting. The Department of Labor issued some FAQ guidance not too long ago. Actually, I think it was on Friday. DOL dropped late some FAQ guidance that said, in essence, please everybody just do the right thing and we'll worry about all this other stuff later. So this was FAQ implementation 42, I believe is what it's called. And question and answer 9 and 10 essentially says, look, folks, we understand that ERISA has these requirements about sending an SMM and formally amending your plan. You got these mid-year election change rules that plenty of my colleagues, lawyers, have been telling people, wait, hold on, you don't be so fast to jump on coverage changes and the coverage of diagnostic testing for no cost sharing, all these other problems. DOL essentially said, look, folks, we're in a crisis. So how about we not worry about all this paperwork and just get the job done? Let's take care of people. And in its very bureaucratic terms said, we, the DOL, are not going to enforce the notice requirements of mid-year changes to your plan. Again, that was DOL FAQ implementation, I think 42. And it was questions 9 and 10 for those of you nerds who want to go look it up. But essentially what my reading of that is that the DOL, well, I mean, they're bureaucrats, but they're still people, and they want people to do the right thing. And I have some confidence that government bureaucrats will do the right thing ultimately. And that's very good evidence of that essentially, your SMM requirement is effectively waived if you're going to be changing your plan in a material way in response to this crisis. So really interesting stuff there. A couple other developments. Let's see. We've got CARES. So we've talked about CARES Act. Oh, yeah, CARES Act coverage mandates. There were some really interesting little nuggets in some of the recent guidance here. So for those of you with high deductible plans and those of you who are brokers who have clients with high deductible plans, huge expansion of the ability to provide telemedicine underneath the deductible that is invading the deductible of a high deductible plan and still maintaining its HSA qualification. That, by the way, has been an issue for quite some time pre-COVID-19, where, because of the way that telemedicine has been structured, it's almost not practical to be collecting a copay from people. Or if you are, like, feeding that back into the rest of your self-insured medical program, those kind of logistics have been difficult. And in particular for employers that want to be able to provide telemedicine is a good way for people to get covered. Requiring a copay adds a lot of logistics. And so here through, if I read the guidance correctly, through the end of 2021, or rather plan years beginning before December of 2021. So for some fiscal year plans, this could last way into 2022. There is essentially a waiver that the CARES Act put into Section 223, which governs HSAs, saying that if you offer telemedicine and you invade the deductible, that there's essentially a waiver of that deductible requirement insofar as you're using telemedicine to invade that deductible. Really interesting development. Other interesting things. So last week we talked with Paul McEwen, a CPA in Ohio, about the EIDLs and PPPs. So let's expand the acronyms: the the Economic Injury Disaster Loan Program through the SBA, and the Paycheck Protection Program through the SBA. And so in a week's time, it seems like all kinds of things have changed, but we do have some developments for you. Remember that under the EIDL program, that's the Economic Injury Disaster Loan, it's an existing program with SBA. There's this $10,000 grant that's built in. And it's also referred to as a forgivable advance. Those are effectively the same thing. So it is a loan, but you get an advance, meaning that they, just like any other payroll advance, it's a loan, but that advance is forgivable so long as you spend the money on the right stuff. And the advance is given notwithstanding the fact that you may later be completely denied for an economic injury disaster loan. Well, that's a really interesting, it's so effectively making it a grant. So we, ERISAfire and Lefevre Law, this morning, right before we got on the air this morning, received an update from the SBA in response to an EIDL application that we made, largely because we're curious and also want to be prepared. So, so indeed, SBA has begun kind of a rationing process for these grants. So Paul mentioned this a little bit last week as a suspicion. That suspicion is confirmed. It is $1,000 per employee, up to $10,000. So for very small businesses, it's only going to be, $1,000 per employee that you're going to get as an advance. I found it encouraging that I actually received something from SBA. So while it feels like it went into the ether, it looks like things are being processed, albeit, a little slower than maybe Congress had intended. Perhaps an indication that Congress's intentions were a little unrealistic, or expectations rather were a little unrealistic. So that's interesting and good news that things are being processed. I am seeing some news reports also of some of these EIDL grants being funded, so that's good. You can apply for both. So if you have a business, or if you have clients with businesses with fewer than 500 employees, or otherwise meet the Small Business Administration's criteria for being a small business, there's a revenue test. Then it would be incumbent upon those clients and you as employers who meet those criteria to apply for an EIDL. Personally, I just don't see much of a downside to it. As long as you can spend it on the things that it's supposed to be spent on, and there's some edge cases where it doesn't make sense. If you've had to furlough all of your employees and shut down your business because you're a brewery, for instance, and the city has ordered you to shut down, the loan or the grant restrictions, that is, you have to spend it on essentially employee payroll, may not make sense for you because you don't have employees that you can pay at the moment. And so to bring them back very temporarily without knowing all the rules and whatnot, that's tough. So it may not be for everybody, but for most businesses under 500 employees, it just makes sense to apply for it. It is a very simple web application form. As I mentioned, you can apply for both the EIDL and PPP. Some developments there. The national banks are acting like national banks. And we've experienced this ourselves. The full-blown underwriting process for any kind of a loan is being used. And you may have seen in the news that Mark Cuban, who owns the Dallas Mavericks, among many other things, he's on Shark Tank and whatnot, has publicly blasted the national banks because they're taking people through the entire underwriting process, even though this is supposed to be largely a forgivable loan that is, essentially free money, as long as it's spent on the right purposes. People are having better luck with community banks, that they're a little less driven by process and more driven by people, which is good. Another really interesting development: if you have clients, or if you are a business that uses Intuit, which owns QuickBooks, Square, the card reader, or PayPal as a processing system, all three of those fintech or financial technology companies have been approved by SBA to provide Paycheck Protection Program loans. Really interesting stuff, because if you didn't know, Square has a payroll program. Intuit, QuickBooks, has a huge payroll program. And PayPal is just a financial giant. And so what's really interesting is that some companies that are in more of like the payroll and processing of money side of things are getting into making these PPP loans. And if you recall, a Paycheck Protection Program loan is based almost entirely upon payroll. So if they've already got the data and they've been approved by SBA, they're promising that they're gonna fast track people's applications. So really interesting developments there. There's also, if you're not getting any love from your financial institution, there is another fintech called Fundera that is kind of a rocket mortgage sort of for business loans. That's just a loose analogy. That similarly has banking institutions, a lot of smaller banks, where you can apply with one place and one bank will take your application. And so there's all kinds of fintech companies that are getting into this Paycheck Protection Program loan space and are treating it less like a commercial lines loan and more like a grant, like SBA and Congress intended. So just some really interesting developments there. I want to make sure that we have plenty of time for our guest today. So I'm just going to preview a couple of other things. If you are an employer with more than 500 employees, recall that the FFCRA and its tax credits are only applicable to employers under 500. There may be some ways to slice and dice your business to get under 500 if you're looking for some tax credits. But if you can't do that, there is another tax credit available called the Employee Retention Tax Credit for employers over 500 employees. It's not a one-to-one with the FFCRA paid leave tax credit, but it is a 50% tax credit for keeping people on payroll, which could be really, really advantageous. So Congress and the Treasury Department are just absolutely throwing money at this. And so you want to make sure that you're taking advantage of everything you can. So employee retention tax credit, we can talk about that a little bit if folks have questions. A couple other things. So here's where being a benefits nerd comes in handy. There have been around for many, many years, a couple of programs under the Internal Revenue Code that allow for preferential tax treatment of certain things. One is called a subplan or a supplemental unemployment benefit plan. And it's a private deal where if you are going to be furloughing employees and you normally have a big severance payout right when the employee severs, or if you have an ongoing program, you got to pay FICA taxes, and if you're providing an ongoing program, they're not going to be eligible for state unemployment. There is a way to structure your severance program so that it coordinates with state unemployment insurance. Really, and it's been around for a very, very long time. And I'd kind of forgotten about it, but there is a way to structure your severance program so that it coordinates with state unemployment, basically getting the state to pay some of your severance program, and you can avoid FICA taxes. The employee and the employer both avoid FICA taxes on it. There's some plan documents that are required, and because it's IRS, there's some small strings attached. But if you can administer the program the way that the IRS says, there's a really great opportunity if furloughs and severance is kind of an inevitability for your business. So if you're interested in something like that, please do reach out. The technical details are such that it's not, we wouldn't be able to cover it here, but reach out and we can lend some assistance there. The other one is Section 139 disaster benefits. It's a way to provide employees tax-free money for, and it's deductible to the employer fully, no FICA FUTA taxes. It's just free money not free, sorry. It's just tax-free money to employees to cover disaster-related expenses. There's not a lot of guidance on what disaster-related expenses means, but we have some indication based on some Treasury regulations under other circumstances, 9/11, hurricanes, tornadoes, et cetera. Some things to think about. If you're looking for ways to get some employees some money to help them get through this, there is a tax advantage way to do that. Again, the details are such that it's not well suited for this kind of a presentation. Do ask us. And in particular, if you could chat Kendra your email address if you're interested in knowing more about a sub-plan or Section 139 disaster relief benefits. Especially that sub-plan one. That's enormous for a lot of employers to be able to reduce their severance benefit and essentially coordinate with state unemployment and avoid FICA taxes. Really great tool. All right, so those are the kind of top of the hour. Here's a blast of information just to get everybody's minds going and to generate some questions. And right before we bring on our guest here, we have a quick word from our sponsor. So we are ERISAfire. We are a multidisciplinary team, journalism, insurance, and legal. We perform a wide range of services, all employee benefits related, everything from the mundane plan documents of 5500s to the real in-depth consulting on things like HIPAA and contract negotiation and all those non-discrimination testing and consulting on leave and all those kinds of things. And why would a company like ours get into the weeds of plan documents of 5500s and 1095 reporting? And it's because we value relationships very much, and we want to walk along beside employers with things that they're already doing, so that we can get to know the client better, to improve those services too, the plan documents and the 5500s and the 1095s. And the more we know, then when things come up like these kinds of COVID-19 crises, we're already in a position to provide very specific advice because we already know the risk tolerance of the business. We know their culture and can help accordingly. We've packaged these things into very affordable retainer programs. And in fact, actually, if we've got some people here who are with one of the insurance agencies we work with. If you have questions along the way that we did not get to during the program, do reach out to your agency to see if we do have a retainer relationship with that agency, because offline we can handle your questions under such arrangements. And if you're interested in one of those things, please do reach out and chat Kendra your information. All right. So without further ado, I want to introduce to everybody Mr. Eric Buchanan. He represents disabled people and other policyholders across the United States in both ERISA and non-ERISA disputes, focusing primarily on the areas of disability, life, and health insurance. Eric has represented over 1,200 people in Social Security hearings since 1995. He is certified as a specialist in Social Security disability law by the National Board of Trial Advocacy since 2007. And he has served as president of the Tennessee Trial Lawyers Association, among many other positions. Eric graduated from Virginia Military Institute and served as an officer in the U.S. Navy, where he served as a naval aviator, that is a pilot, plane commander and mission commander for the PC-3 or P-3C Orion anti-submarine aircraft. That's pretty cool. Eric, welcome to the show. I have one question for you here real quick. Let me get out of full screen mode. Okay, I gotta ask, is watching Top Gun a bit like a surgeon watching Grey's Anatomy?
Actually, the one that I watched like that is, you remember the old movie Officer and a Gentleman?
Yeah.
That was a lot more like what I went through in the first few weeks of flight training. They did a version of that for officers who had already been through ROTC that was shorter, but being dumped upside down in a swimming pool in a plane that was a thing that was a fake crash, being dragged across a swimming pool with a fake parachute on, with the fan blowing the water in your face, you couldn't breathe, doing the obstacle course. That was pretty neat. Hunt for Red October was a lot more like what I did than watching Top Gun. So, I didn't get to be a jet jock. It was fun flying P-3s, but I was not Tom Cruise.
Fair enough. Well, first of all, thank you for your service. All of us greatly appreciate your sacrifice for our country, and we really appreciate it. As we've told some folks, you represent the plaintiff side of things, and there are a lot of people here really interested in your perspective on things. A couple of kind of newsworthy items that I'd love to have a discussion with you about. I've been reading that there are a few employers. Well, back up just a minute. This week, it's expected that folks are going to be getting their individual stimulus checks, right? So the $1,200 from the federal government, plus some step ups for some things. So there are a couple of employers who reportedly have been telling their employees, we know how much you make, and therefore how much your stimulus check is going to be, and we're going to deduct it from your pay. Okay, so moral implications aside, is that legal? Can they do that?
Yeah, so I think the short answer is no, obviously. I haven't seen any indications that there's going to be some kind of allowance in the law for employers to be allowed to deduct those. And I'm not so sure legally it makes sense. And I'm also pretty sure morally it doesn't make sense. And I'm going to go ahead and start this thing that you and I talked a little bit ahead of time, the theme of doing the right thing as an employer. I'm a small businessman too. I've got 16 employees. There's a lot of this stuff that's affecting me, and I help a lot of people that have employee benefit problems. And ultimately, what am I trying to do to get through this is to help as many of my clients as I can, having people work from home, keeping our office running with all the restrictions and the smart ways of doing business. And at the end of the day, survive doing the best job we can and have a great team to continue to help people when things get back to being either normal or at least more normal. And so as an employer, I'd be thinking, I'm trying to do the right thing. I want to keep people hired. I want to keep people busy. I want to be able to pay them if I can afford it. And playing games like, and I'm just going to call it that, playing games like, we're going to deduct from what we pay you the amount that you're going to get from the government, if nothing else, is going to make employees mad at me as an employer. And do I really want a team of people working for me that I've done that to? Maybe some employers can get away with it. It doesn't seem to make sense, but I also think it's going to cause some problems. Whether it's something that's actionable is probably going to be a problem under some of the Fair Labor Standard Act rules, depending whether you have the employee working or not. But certainly it's something that goes against the whole idea of how you're going to get loan forgiveness under the Payroll Protection Plan Act. And we can break that down a little bit if you want to, but essentially, if you apply for that money and you use 75% of it to keep paying your payroll, then you're supposed to get that amount forgiven. Well, if you pay less in payroll, that's less that you're going to get forgiven. It just doesn't seem to be a very productive attitude.
Most definitely, you know, and the news reports are large, are allegedly very large companies, so like national chains, if you will, and so you know, so they may not be. That's good. That's a good recommendation for folks who are small enough to take advantage of the Paycheck Protection Program. That doing that, trying to get, you know, what is essentially free money from the government plus you know, taking your employees' stimulus checks, that's a conflict and would present some issues for larger employers for whom that might be attractive. You know, they might not be eligible for the PPP, but I think your point about the Fair Labor Standards Act, you got some minimum wage issues, notwithstanding the moral issues involved. That was just one of those things that just struck me as kind of unbelievable, but at the same time, kind of not. You know, we have these dual themes that we've talked about. You know, like let's do the right thing, and kind of for the most part, things are going to sort themselves out. But then again, we know some people won't, and you know, so. My question to you is, you know, is that if you hear of something like that, if a client comes into your office and says, look, this happened, is that the kind of thing that you're gonna look at and say, you know what, let's look at the Fair Labor Standards Act, let's look at the state payday laws. You know, is that something that would get the plaintiff's bar maybe riled up a bit?
Yeah, I mean, obviously, if one person came in with a story like that, we'd want to look at the facts a little bit more and make sure we understand what was really going on and look into it. I think there's going to be a lot of fact-based inquiry going forward. It's certainly something that could potentially be a source of some good cases. Going back to our theme of doing the right thing, I think another way that I'm looking at this as an attorney is we are in emergency mode right now. Everybody is. I've got 2/3 of my people working from home. Most employers are lucky if they have people that can work from home and continue operations. In some places, obviously, like you discussed a brewery earlier, that can't. What's going to happen with these kind of legal issues, with employee benefit claims, with employee payroll claims, 3, 6, 9, 12 months from now when these cases end up in court? I think one theme, of course, is going to be did the employer do the right thing? And I think another question I would be ready to ask a judge if I'm helping an employee is, why did the employer do what it did during this emergency? How is it going to look for that employer 12 months from now when we look back and say, well, that made sense. That was something you had to do because there was an emergency. The way you acted, that's understandable. That was in the realm of reasonable behavior during an emergency, versus there's certain things you should continue to do following the law for the most part. And I would feel very comfortable asking the judge, well, why couldn't they go ahead? Why couldn't this employer continue to follow this law? Why couldn't they continue to do the right thing? What was the good reason that they had for not doing that? So as long as an employer kind of generally is trying to do the best thing, that's going to cover a lot of stuff. If they do something dumb or mean, I'm not going to be a problem standing in front of a judge in the future and saying, Your Honor, why did they have to do that? That wasn't part of the emergency for them to mistreat their employees this way or to do this to this person. It wasn't the time to fire somebody who was 63 and was about to vest in their pension plan, who'd been a good employee for 33 years. Why would they pick now to do that, Your Honor? Those kind of questions is not what employers want to be facing a year down the road.
So that's a really, really interesting thing. And it essentially boils down to the judicial system is made up of people too. Judges are people. And so one of the things that I'll talk about with an employer when we get into this kind of risk management analysis, because I'm always on the front end, right? So we're always advising employers, sometimes during disputes, but for the most part, we're giving proactive advice about what to do going into a situation. And one of the phrases I'll use is you don't want to be the bad actor, right? You don't, while you and I learned in law school that everything's principles based, and the law says this, and if this principle applies here, and then, a set of slightly similar facts, that same principle will apply. Like, we learned that kind of formulaic application of law in law school, but then we get into practice and realize that's not actually how it works. Bad facts make bad law. In other words, judges are people too. And, if the evidence looks like the employer was trying to do the right thing, it's unlikely, especially if there's discretion, that the judge is going to impose a penalty for, some Mickey Mouse violation of something. Or similarly, when you're taking a case, if it looks like the employer is trying to do the right thing, you're maybe less likely to take it, as opposed to client comes in. And I really appreciate that you do get into the facts and you want to dig a little bit. But if the facts look like, the employer really was trying to get out of an obligation that it had in the first place, like, that's a good story for you. And so yes, doing the right thing actually matters when you're talking about risk management and compliance, because 12 months from now, when the courts do reopen and claims start coming up, the claims that get moved through the system are going to be the ones, and correct me if I'm wrong, but are going to be the ones where the story is where it looks like the employer was the bad actor.
I think that's definitely going to be a big part of the decision-making process, at least for good attorneys going forward. They've got to take that into account. I think you brought up something very interesting earlier about those Q&As from the Department of Labor. We're in an emergency situation, so maybe not getting all the documentation out to technically comply with ERISA's notice requirements. We'll all figure this out, and we're not going to force his rules, says the Department of Labor. I think that's a good example of something where I'm certainly not going to sue for a violation of ERISA notice penalties for a client, next year under ERISA Section 502C to get the $110 a day for not getting the notice if it was something like that. On the other hand,
by the way, but that is on the minds of people who are listening right now. That penalty you just cited, because we get all kinds of issues with mostly out of network providers threatening that $110 a day.
So that was something.
Sorry to interrupt, but that's real. That's very real to these folks.
Right, and so so not putting out the notice when you change the plan a little at the and you're required to do that each year, getting that out late because the insurance company didn't have the people available to put the plan together, or you didn't have a way to actually print it up, or whatever the reasonable reason is. That's very understandable. On the other hand, let's say I will have, I'm sure, some client coming to me who's covered family member dies because of the coronavirus, and some health insurance company, and they got some life insurance company, they got their life insurance at work, might be denying that claim because who knows, that just things happen. Insurance companies, these claims turned into disputed claims. If I write a letter to the employer and ask on behalf of my client for a copy of the plan documents, and the employer doesn't provide those documents within 30 days as is required under ERISA, I think one of the big questions that a judge is going to be answering in that case a year from now is, well, was there a really good reason the employer couldn't find those plan documents, or were they just saved on a server somewhere and somebody working from home could have pulled them up and emailed them to me, and then everything would have been fine? It's going to be that kind of fact-based inquiry.
If I'm trying to help, documents didn't exist in the first place.
Yeah, if I'm trying to help a client understand the rules of why a claim was denied and whether they have any rights to pursue that claim further, it really shouldn't have been denied. An individual request for plan documents, I think, is something that it's going to be hard for employers to say, well, even if they're the brewery, well, we were shut down. Well, could somebody at least go to the office and grab a copy of it and scan it in, or drop it in the mail or something? Those are going to be the kind of questions that courts are going to be answering later on. And so if employers, I had a really good reason. our brewery had been infected. We'd had employees with the active coronavirus and we couldn't go in there. Okay, that's a great reason. Well, I just, I didn't want to do that because I was trying to work from home. Well, this might have been one of those times you need to go into the office to grab something, even if your business is shut down, because there was a real employee with a real live active benefits claim. That's the kind of stuff that's, I think, gonna shake out in the litigation for the next couple of years after this is that retrospective question. The court's going to ask, well, was that a reasonable reaction to the emergency, or was that something employers should have still been able to handle?
And is that true in your experience, even if there's not an actual legal element of discretion for the judge, like just judges being human? Because, for instance, the ERISA penalties for not providing plan documents upon request is discretionary, right? So a judge has discretion to impose that penalty or not. So the good actor, bad actor thing is very relevant there. But in your experience, even for either state penalties or other ERISA penalties that do not have an express element of discretion for a judge, is the story still relevant either from a legal or a human perspective?
Yes, absolutely. I think that's one of those big secrets you learn once you really get to practicing law. Like you mentioned earlier, no matter how clear cut the law reads and the facts are that fit that fact pattern, if at the end of the day it doesn't seem fair to the judge, good judges are more likely to shade their understanding of the facts, would be a fair way to describe that, so that they're not going to come up with an unfair outcome. They might find a way to rule more in the employer's favor or the employee's favor, kind of depending on what was really going on. Now, of course, we've both seen cases where judges say, well, this is the black letter law and this is what happened, so this person should lose or this person should win. But the reality of the facts on the ground, of what actually happened in a certain situation, I think that's really going to be important going forward. Remember that right now the judges are sitting at home wondering when they're going to go back to court. A lot of courts are still doing audio hearings and they're making decisions on written briefing, but hardly anybody's doing anything in person in a court anymore. Pretty much just limited to criminal proceedings where someone's actually in jail and needs to have a hearing, to have a bond set or something like that. For most cases are proceeding, judges are making decisions, judges are hearing arguments, they're allowing for phone hearings or video hearings. Unless you need an actual witness to testify, most stuff is actually still going forward. At least most federal courts are doing that, and a lot of state courts are trying to do the best they can. So the judges are used to seeing, what can a business do during these times? What are the reasonable steps we can take to make things continue to work? And if an employer has somebody who's actually working from home who has access to plan documents, and a request comes in for plan documents from an employee who has a question about their benefits, it's going to be hard for a judge to say, well, why couldn't you, oh, there's a coronavirus, so you don't have to do anything. You can stop working and stop following the rules. No, the judge is going to say, well, why couldn't you just email that on over if you had access to it? If it's that reasonable, if that's what's going on, judges, I think, are going to understand.
Yep. Yeah. So again, a very human element to what's going on, and to maybe debunk some of the myths people have about how the process works. Wow, a tremendous perspective. So that opens up another kind of line of thinking for me, and that's that there's all kinds of obligations. I mean, human resources workers are overworked and underpaid as it is. And so, now we throw a pandemic crisis and financial crisis on top of that. So, judging what to do right now, we've got all this new stuff that grabs our attention, but what you're saying is there's a lot of existing obligations that we don't want to lose sight of. So what kinds of things are on your list? From the plaintiff side of things, like what kinds of things would be your expectation of employers to keep doing, notwithstanding the things changing a lot?
Yeah, so that was the big one that would come to mind first is, as and a lot of employers know that have a good HR department, if an employee sends in a written request for a copy of their plan documents, employers have 30 days to provide those plan documents or can be penalized up to $110 a day. And actually there's an incentive for employees to sue for that because the money goes to them. The employee and their attorney get the $110 a day plus attorney's fees. I have actually litigated some of those cases where it's been, frankly, the good cases, employers have been amazingly negligent or even adversarial in providing those plan documents. And I don't know why it happens sometimes. 90% of the time, 95% of the time, employers turn over those plan documents. But every once in a while, I'll get a letter back that says, we're not giving you anything without a court order, or we're not going to give you anything because you're not entitled to it, or we don't think that this applies. And the good cases are ones where we've written 3 or 4 letters asking for the plan documents, and we still don't get a full story. And a lot of the times we want those plan documents, not because we want to get the employer in trouble. We want to know what the rules are for this particular health insurance policy or life insurance policy or disability policy. How does it actually work so we can protect our clients' rights? And we have had judges award $110 a day for, I think the biggest case we've had is about $75,000 penalty we had a few years ago where a union had a professional administration company that was supposed to respond to those requests and ignored 4 requests over a 3-month period. They ignored 3 requests, and in 1 request they sent us 2 pages of the SPD and said, this is all you need. Well, we'd like to see the rest of the SPD and the actual plan and the underlying long-term disability, or actually it was a life insurance policy, and they never gave us that stuff until we were in court. And ultimately, a court penalized that union $75,000 just for the failure to provide the plan documents. Those cases are out there. They're rare. Most employers comply, but that would be a good example of something that I would expect courts are going to expect employers to still make a good faith attempt to comply with that rule. Tell your employees what their rights are to their benefits. And a lot of those questions are going to come up. Employees are going to get sick, whether it's from the virus or it's something else. They're going to have issues with their healthcare plan. You and I discussed before we got started that some health insurance companies are denying claims right now until this all gets straightened out. Maybe the coding's not done right. Maybe there's a dispute about reimbursement. But if a client comes to me and says, 3 weeks in the ICU is how many tens of thousands of dollars and it's not getting paid. Well, why is it not getting paid? Well, they won't tell me. That's, to me, factually a good case that I'm going to be looking into as a healthcare claim. And then maybe asking the employer for the plan documents to find out exactly what the plan originally said, plus any of the new laws that say what health insurance companies are supposed to cover. I can see those kind of cases are going to happen. We talked a minute ago about life insurance claims, but I think, hopefully not that many people are going to pass away. We're still below what most of the models said. But frankly, I've had a first cousin whose wife passed away due to the virus. And so it is affecting people. Yeah. And the first cousin himself is still in the ICU in Seattle, by the way. And so we're hoping for the best for him. But having known a family member who passed away, I know these things are going to happen out there. And without sounding too mean and cynical, but as a plaintiff's attorney for the last 25 years, there's going to be some insurance companies that are going to deny some claims. I can feel it in my bones. It's coming. And when somebody comes to me and says, my mom passed away, my dad passed away, my spouse passed away, and the insurance company doesn't want to pay because of reason X, Y, or Z, and they had this policy at work that's supposed to provide, $300,000 of life insurance, those are going to be interesting cases, depending on why the insurance companies want to deny. I can see some reasons. I'll give you a quick example. Some life insurance policies have an exclusion. If you get the life insurance at work, they don't cover work-related injuries or deaths because that's supposed to be covered by workers' comp. That might be an exclusion that you see in some group life insurance policies. Well, where did that employee of the big box store get exposed to the coronavirus? Was that at work? Well, the life insurance company says, well, we're going to assume that they did, and therefore this is not a covered life insurance claim. That may sound harsh. Having done this for a long time, I can see it coming. I wouldn't be making a living and have all these attorneys.
I don't know if you're following much of the financial news, but insurance companies are heavily invested. I mean, that's the whole point, right? They're essentially, one side investment house and one side sales house. And in order to pay those claims, they've got to invest dollars. Yep. And if they lose 30% of the value of their investments, It might be a little tighter on the money on the claims side.
Yeah, it's interesting you say that because I used to describe insurance companies as being divided into thirds. There's a third selling the policies and correcting the premiums. There's a third investing the premiums that come in, and the other third are supposed to be deciding who gets paid what claims. And the reality of the world is those claims departments have, whether they want to admit it or not, it's company money that's being paid out, and depending on the insurance company, sometimes the culture of those claims departments can be, if in doubt, shade it toward the side of the insurance company getting to save that money. And like I started to say a second ago, I would not have 5 other attorneys working for me doing these life insurance long-term disability claims if we didn't see a lot of times where we didn't feel really good that the insurance company's decision was wrong and should be overturned. It's what we do for a living, and we got a pretty big firm doing that. Big firm for our type of practice area.
Yeah. So on the employer side, then, is there kind of a gap? Well, let me back up for a second and explain. I can tell you most employers we talk to are blissfully believe that there's an insurance policy. They bought into a life insurance policy, a disability policy. It covers what it covers. There's no way the employer could ever be on the hook for anything because it hired an insurance company, or rather purchased a policy to cover all of it. So why am I in the middle of this? Realistic? Not. What is there a gap?
There's a huge gap. And it's one of the things that I frequently discuss with my friends who sell insurance policies is, what conversation have you ever had with an employer that you sold a group policy to about what their obligations are under ERISA? And I get a blank stare from the insurance agents.
Yeah.
And I actually regularly speak to insurance agents and employers, because I don't want the employer to be in the middle of this fight. I don't want the employer to be the bad guy. I don't want the employer to be part of the lawsuit. If an insurance company's claims department is going to deny a claim, that's just the reality of the world. That's going to happen. That's the fight that I'd like to have on behalf of my client, is between the claims department, the parent insurance company, and my client, and that's the fight we're going to have. Unfortunately, most employers don't understand, or not given a class on what happens when they offer employee benefits, that they just became, in most cases, a plan administrator. And a plan administrator, for those of us that went to law school, is a whole lot like being the trustee of a trust with a lot of fiduciary obligations. They have to provide information. They have to tell the truth. A lot of courts have said if somebody asks a general question about their employee benefits, the employer as plan administrator has to answer questions that the person didn't know to ask but should have known to ask. They have that level of a fiduciary responsibility to fully explain how their benefits work. And it goes back to what we were talking about earlier. It's not just providing the plan documents when an employee requests them, but if the employee asks a question about how this plan works, it's the employer who is deemed to be, in most cases, the plan administrator, who has an obligation to truthfully answer the questions, provide a copy of the policy, and say, well, this is how it works, or this is how this particular part of it works. And all those obligations fall onto the employer. And we can have a long talk as ERISA nerd to ERISA nerd about how the law developed so that became the rule. But that is essentially the rule, that it's not the insurance company that gets sued for not turning over the documents. And it's usually not the insurance company that's sued for giving bad information. The insurance company usually gets sued when they deny a claim. But the employer can be caught in the middle. And it kind of goes back to this general theme about doing the right thing. If you're the employer and you get a request for information, try your best to give the accurate information. That's going to make it less likely that some attorney is going to sue you, the employer, for getting involved. Give the right information, give the plan, turn over the plan documents, and don't guess about what a plan might say or what your insurance policy.
That's a really great point, because and that I want to highlight, that doing the right thing, especially for people in caring professions and people who are in HR because they want to help people. The cases that I see and the conflicts that I see often are the ones where somebody was promised something wearing the hat of the plan administrator. Oh yeah, you're going to be covered. We paid your premium. Well, turns out you're not actually eligible because you were not actively at work. We've talked about that on the program here a couple of weeks ago with furloughs and things like that are kind of in between working and termination of employment. Like, what does that mean for a disability policy? What does it mean for a life insurance policy? And being overeager in answering the question without actually consulting, like,
So can I give you two more examples
please.
of where I'm seeing this a frequent area of litigation where these cases are ending up in court. The one is going back to the guessing scenario. Um, Somebody goes out of work and they have a workers' comp claim, and they also have a disability policy at the company. Most company disability policies have a financial offset. Just the monthly benefits are usually reduced for what the person gets in Social Security disability and in workers' comp benefits. Well, if you have somebody, for example, who gets sick under the coronavirus, is in the ICU a couple weeks, thank goodness they recover, but they're not ready to go back to work for another 2 months. If they can show that they got the coronavirus at work, that might turn out to be a workers' comp claim. We'll see how those kind of cases shake out, or at least it might be a situation where that might come up. But even just in the normal course of business, somebody gets hurt on the job. Here's the bad advice I see. The person goes in and says, I want to apply for long-term disability while I'm out on workers' comp. And the employer says, and I've had more than one case where this has happened, and the employer's HR department says, you cannot get both LTD and workers' comp. Apply for the LTD once your workers' comp case is over or it's settled. Well, it takes 2-3 years sometimes for the workers' comp case to be paid temporary benefits and eventually reach a settlement. And then they go back to apply for long-term disability, and the parent insurance company, the Unum or Hartford or Aetna or MetLife, whoever it is, says, no, you were supposed to file a claim within 90 days and you missed your deadline by a year because you followed the advice of your employer. Somebody in the HR department didn't understand that the right answer is that the person should have filed the claim for the long-term disability. And if the math worked out that there were no benefits available for the first 2 years because of the offset, that's fine. They still need to file the claim. But by telling them to wait till the case settles, till their workers' comp case settles, to file the claim for long-term disability benefits, that employer just became a fiduciary who gave bad information to make somebody lose their benefits, and that's a breach of fiduciary duties case.
And it's actionable under ERISA, right?
Yep.
And the damages are essentially equal to the benefits that were promised but not delivered.
Yeah, basically. I mean, there's another ERISA nerd talk we can have over how you measure the damages in fiduciary duties cases, but that effectively is what most courts are now saying. Another example, and this is what I'm might be relevant to this time period where you're seeing people having a fear of this virus. It might be a good time for me to update my employee benefits and take out the maximum life insurance that the company offers. I have had 3 cases in the last couple of years where that fact pattern has turned into another breach of fiduciary duties case. And the fact pattern is this: the person goes into their HR department and says, what's the most coverage I can get under our company life insurance plan? I've been doing the minimum, or I've been doing what is free, what you guys provide. I'd like to increase the coverage. And some kind of misunderstanding at on the employer's side, or miscommunication between the employer and the life insurance company, results in the employer telling the employee, oh, you've now got the maximum coverage. You've gone from $200,000 to $650,000 in life insurance coverage, when in fact the policy says you can only bump it up $50,000 at a time without proof of insurability. But it's the employer's job to pass that on and say, if you want to increase it more than $50,000, the plan says we have to tell the insurance company, and you have to get the proof of insurability submitted, and the insurance company has to approve it. The insurance companies argue in these cases, it's not up to us to figure out who is entitled to what amount of insurance. We just get a statement from the employer that is the list bill of everybody who's paying for the insurance, and that these premiums are being paid, that it's the employer as plan administrator who's supposed to understand under that plan and not promise more than what the plan provides. So the person would have been allowed to go from 250 to 200 to 250,000 without proof of insurability, but the employer says, no, we've set it up, you're now getting the maximum. Let's say that's $600,000. So the insurance company, when that person dies, says, look, the most we were going to cover is the 200 originally plus the 50,000 increase. We never got proof of insurability. The other $350,000 we're not paying. Well, who's on the hook for that? Is somebody on the hook for that? Yeah. And that's a case that we've successfully litigated. Well, one time we won, and a couple other times we've settled cases with that same fact pattern, because somebody at the employer didn't understand how the company life insurance plan actually worked and gave bad information. And in fact, in all three of the cases we've dealt with that, the employee was actually charged the full premiums for the maximum life insurance for the 600,000 in that example. So they had a great case of, I was given bad advice, maybe in an email or something, so it was documented, and I was paying the full premiums. And courts are pretty sympathetic to somebody who's paying the full premiums and has a written statement that that's what your coverage is. And in those cases, it's almost always the employer that is who the court's going to look to say, you guys have to pay here because you were the ones that gave the bad advice.
Yeah, we've been following that, and I would love to have a further ERISA nerd conversation, because we actually developed some ERISA wrap plan document language to address exactly those scenarios and hopefully provide an employer an argument to get out of those lawsuits about this whole mistaken premium thing. So that's actually something we developed specifically for our brand of ERISA wrap document. But we'll have that conversation another time. It's a little after 11 here. I want to be respectful of everybody's time. Eric, thank you so much for coming on the program today. It's been wonderful talking with you. Folks, if you have questions, we're going to leave it open here for just a few more minutes that you can populate your questions. If you've provided an email address, we'll try to get back to you, or we'll just be adding some FAQs to our website, help.erisafire.com, throughout the week here. So thank you everybody for your time. It's been wonderful, and stay safe and stay sane.